they have been facing some problems, and they try to find out a solution of that problem. So, whatever the problems people face, human beings have been intelligent, genius, whether educated or non-educated, whether PhD or a non-PhD, a BTech or non-BTech, a person who is illiterate or illiterate. So there are people who have been, now just look at the which was the first most important invention in the world. Tell me, the first most important invention in the world, human mankind. Any answer?
So wheel.
Correct. Wheel was the first invention, and the person, our thousands of generations ago, when we did not know what is electricity, we did not know any damn thing. That time, wheel was invented, and that was invented after how many millions of years of human beings existence on the earth. So at that time, you cannot say a person was educated, therefore that person invented the wheel. So people who are intelligent will always invent something which is very useful, very good, and very useful for the people. Then the people who are educated, they have got a better opportunity. They are more fortunate to invent something. So the like Jugaad inventions have been done not by IITians, not by the NIITians, but by the common man. Okay, they found a problem, they solved the problem. And I had been telling earlier that the invention is a technical solution to a problem faced by the people. So uh, now in the organized R&D, it may mean management of entire process of research from the original conception of invention to obtaining of patents to licensing or commercialization. So it is a total activity if it is organized research. And there are so many organized researches which have been done, and we have discussed about it. It can be from the MNCs or large companies or small medium enterprises or academia or even NGOs. So, or by a common man. Anybody can, there is no monopoly right on of anyone on the invention or inventive process. Now, while obtaining the patent, the key decisions are: one is in the R&D phase. Now, this is R&D phase is from conception of the new idea and invention to filing of patent application. So once you have done the R&D, then you would and you should file a patent application. And second phase is the legal phase. The legal phase is from filing of the patent application to grant of patents, because there are so many issues. Once you file a patent application, the patent office, uh, that means the patent examiner will scrutinize the application, and there may be certain queries from the patent office raised by the patent examiner, and these queries are to be responded to. If you don't respond to the queries, they will stop further processing of the patent application. Nothing is done after that if you don't respond to the queries. And this is typically the case with the patent applications filed from academia or academic institutions, because the main purpose of academic institutions in doing such research is or such inventions is not the invention research per se. It is a research scholar or MTech student is going to get a degree. So the main purpose is to get a degree. So the student is going to get a degree, and PhD supervisor is guiding the PhD thesis. So their main objective is not the patent and the thing. Everything is a byproduct of the process of academic system. But if it is a commercial organization, they are very keen about patent application, patent application filing, and then protecting it as much as possible, keeping in view that what is more economic, viable, and appropriate, what is feasible. If the patent is very, very important, maybe by a small company or by a medium-sized enterprise or a large company or MNC, they would like to file it at a very large number of countries. And they would also make effort for licensing it. Or the small company would like to license it out, but big companies or multinational companies, they would they may not be interested in licensing because they would like to have their own product being sold in all the countries and ensuring that it is not being uh, uh, the you know, their product is under patent and no license given to anybody else, so they can sell the product at a higher price. You know that when this normal our digital calculator came for the first time, this uh, 5 6 functions plus minus division multiplication percentage and equal to these 6 functions, this calculator was 40,000 rupees in late 60s, early 70s, 40,000 rupees. But then the prices kept coming. And this is known as skimming price policy. That is to skim the cream of the market. You make the product in limited quantities, keep very high price. So the people who are eager buyers, those are very eagerly wanting to acquire new products, maybe for the snob value or for uh, other reasons, they will acquire the products at any price. Same thing happens typically when the movies are released. Uh, Earlier days, there was a concept when this computers, internet, and all these things were not there, mobile and all that. So the films used to be one of the uh, most important means of entertainment, and people used to see the movies. The movie ticket was priced a bit lower during the daytime because people in the office going people could not go to the movie in the daytime. So to keep their hall full, they used to keep a lower price, concessional price during the daytime, 12 o'clock to 3 o'clock. And after 3 o'clock, maybe the students would start going to movies 3 o'clock to 6 o'clock show. And 6 o'clock to 9 o'clock show, most people, families would like to go. And some people, because it becomes too late, 9 o'clock to 12 o'clock in the night, so less people would go there. So that time, people used to, when a new movie was released, first day, first show. So first day, first show, since the pricing was controlled by the government system, you could not sell the higher price ticket, and therefore there was a black marketing. Same was true when Maruti 800 was introduced in the Indian market in 1983 for the first time. At that time, uh, the first few cars which were sold in black, the 48,000 rupees car was sold in 1.5 lakh rupees in black. So all the new products have a premium. So this is the case with all the patented products, new products, which are very important, which are generally based on the breakthrough inventions. They are very highly priced. Uh, uh, you will be surprised to know that the present day, if you go for a photocopy, it takes 1 rupee normally. This I'm talking of IIT type of shops, 1 rupee per photocopy. And when the salaries are very high, income is very high, per capita income very high, then it is 1 rupee. In uh, late 70s, uh, late 70s when the salaries used to be, you know, I think 600 700 rupees for an assistant professor or lecturer. At that time, also it was 1 rupee per page. So whenever there is breakthrough invention like photocopiers and all that, the prices are very high in the beginning. So why it was 1 rupee at that time? It was not the variable cost; it was the uh, fixed cost. That means the photocopy machine was so expensive at that time. Now you get a 15,000 rupees multifunctional laser printer, which also does the task of photocopying or copier. That is 15,000 rupees. And earlier days, at that price level, it was 1 lakh rupees. In 80s, it was a 1 lakh rupees thing, which is equivalent to 15 to 20 lakhs rupees now. But it is 15,000 rupees that is available now. So then second comes the legal phase, and from filing of the patent application to grant of patents. Uh, so in this phase, the objections are raised by the patent office. You have to respond to the objections. Then the process of grant will continue. And then the managerial processes, making sure there is a clarity on the issues relating to protection rights over the invention. There are certain need for some guidelines, and I'll discuss these guidelines. In the research system, the main performing actors are scientists and researchers in universities, government research institutions, like whether it is DRDO or CSIR type, or private R&D units of firms in the industry. Different companies, they've got their own R&D centers, and in electronics, it is very high, very strong. You find the LG is coming up with so many new inventions so frequently. Chinese companies are also very fast in R&D and in electronics, and in pharmaceutical sector. The American MNCs, British, French, German MNCs are doing very fast this research. So then there are non-profit and non-governmental organizations which also do research. These are the main actors. And then grassroots inventors. These are the individual inventors. Anybody can be the individual inventor. And if you do any invention outside your domain of office work, that will be that invention done by you will be considered as individual invention or invention done by the individual. You are the individual inventor. Then in the R&D phase, the cardinal principle is avoid the following. Okay. Uh, Avoid premature disclosure. When you're doing some research, don't when you think that some good result will come, and you keep on unnecessarily propagating for getting some importance, don't do that. Avoid premature disclosure of your invention or publication or use of the invention. Once you start using it, then you cannot go for patent. You will not get patent granted, and even if you get the patent granted, it may be a question by anyone in future if this product was being used in this invention being used in this product, and the novelty was not there, so the novelty will get lost. So avoid all these things by which the novelty will get lost when you go for filing patent application. So avoid premature disclosures, publication or use of the results of research in the public. You should not do it in public. You can have a professional group, a small group, that is okay, but not in public. The R&D, the new ideas and inventions are there. The generation of new ideas and inventions that would lead to patent, and patent after patenting you go for publication, and after publication you go for technology transfer licensing, and after licensing what you get money, and money will make you more prosperous. So this is the cycle one has to follow. About the university research, there is example dedicated to teaching, research, and extending knowledge to the public. That is the main activity, and to carry out its scholarly work in an open and free atmosphere, and to publish results obtained there from freely. Okay, and so and it is limited only by a short time delay in cases in which it is necessary to prepare and file patent application. So the delays are there generally in publication because uh, if you publish it, then it becomes difficult to get a patent on it because the prior art is not there. Once it is published, it is known to the whole world from the journal. So one should not, suppose you submit in a journal and in journal finds very good research. So normally that journal takes 1.5 years to publish the paper, but your research is so good, they say ki bhai, we let us publish it in the immediate next coming this thing 3 months time. And 3 months you thought ki it will be published after 1 year, and till that time you have the novelty. But they have published it in 3 months time because they don't tell you that when they are going to publish it. They will say that we are going to accept it, your paper is accepted for publication, but after acceptance of publication, when they are going to, they say in one of the next few issues, and we'll inform you exactly. But then it is in the press, and they inform you that your paper is being published in the forthcoming issue in next month. Now it is mid-October is already there. On 1st November, the next will come. So all your novelty will be lost because this journal will be available to everybody. So uh, these are the issues which are very important. So therefore, we have to match the two things: filing patent application and uh, sending the research output for publication. It should be suitably matched so that your novelty is not lost if the publication done earlier. Now, every academic institution set up a Office of Technology Transfer or IP cell or IPR cell to provide needed assistance to the faculty and faculty inventors and student inventors. So that is as I think I told you earlier, that MIT at Boston has got the best run Office of Technology Transfer. And there are two things why it is best: because it is best run, and also the inventions which are done at MIT, they are really a large number of them are commercially worthy. Which are commercially worthy, they their own students go for a startup, or uh, they go for a startup, or otherwise they are uh, they license it out. So this Office of the Technology Transfer will license the technologies to the parties which are interested in using of technologies at a good amount of license fee. So they earn more than what they spend in terms of renewal of all the patents and the salaries of all the people who are in the technology transfer office. Now, there has to be balance between public and private interests. Research may be supported by government or industry. The rights and privileges with respect to inventions developed partly or wholly financed by the private parties must be fair and just to the inventors and the sponsor and the public. Uh, Now, this is very important. That is why I have put it particularly in red so that you get a very quick idea. Uh, when a private organization sponsors a research, you put yourself as a private sponsor. You say, okay, we'll give you 20 lakhs rupees and you please conduct this kind of a research. I want this type of output so that I can solve my this problem. The money is given 20 lakhs rupees. Now, whatever the research is done, it is sponsored research. It has been paid for. So the company says that I will own the patent rights for it. But when the company gets a patent, the inventor's name will be mentioned in the patent application, as well as when the patent is granted, inventor's name will be there. Now, the inventor says that it is after all my invention. You only paid part of it because I am getting my salary. The professor is getting his salary from IIT Delhi, and we are all getting our salaries. So you are not paid in full. You are paid only in part. You have partially funded it. You are not funded it in a 100% manner. So this becomes a debatable question, and this debatable thing has to be amicably sorted out. So in academia, the faculty is interested in, faculty members are interested in getting more sponsored research, so that they can, they have more opportunities to do research, which is more practical coming from the industry. So they say ki, okay, we will be willing to give the patent right to them. Some faculty members say, no, 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 the patent should be under joint ownership. When the patent is under joint ownership, then there are many issues which come up. That who will pay the renewal fee? Now the company says, I would like to file this patent in 10 countries. So if you have a joint patent, then the company will say that ki IIT should uh, pay 50% of the total fee, which is to be spent in filing a patent in 10 countries. Why IIT should pay 50 lakhs rupees for one patent to be filed in so many countries? Because IIT doesn't know the commercial worth, even the professor doesn't know the commercial worth. It is the person who is in the industry knows the commercial worth. So there are so many such issues which are there and which need to be sorted out. And they are, there is no thumb rule for deciding these issues. They are to be decided on sui generis basis. That means each issue of such a sponsored research, how it should be patented under rules, this thing, it should jointly patented under joint ownership or what exactly, that is to be decided from on case to case basis. Then the privately supported research should be undertaken by the university if it is consistent with the and complement to the university's goals and responsibilities to the public at large. So this is a very obvious thing that this last point, suppose IIT Delhi, there is no nuclear research center in IIT Delhi. In IIT Kanpur, there is a center for nuclear research. So in IIT Delhi, there is some company says you do this research on nuclear, this thing, and we accept it, and then we are not able to deliver it. So it should be inconsistent with the and complementary to the university's goals, responsibility to the public at large, and also as per their capabilities. In obtaining patents, the recognition of patentability of research is very important. And taking a decision whether to file a patent or not is also important. But now, in India particularly, filing a patent application is considered as a part of the out of the total budget. It is not so big an amount. So decision to file a patent application in India is not really so significant. But yes, if any faculty says that this patent should be filed in 10 more countries, or a PCT application should be filed. PCT application is also quite expensive, which costs you maybe up to 2 million rupees easily. So why should it be done? Should it be done or should it not be done? Because there are many professors who say for every patent filed in India, it is very important. It should also be filed in USA and a PCT application. So then taking a decision when to take a patent, that means when to file a patent application, and then preparing a patent application for taking the patent. How do you prepare the patent application? What you do, you seek the assistance of a legal expert or a patent attorney or a patent agent. These are the things. And filing the patent application with the patent office. These are the key decisions. When do you want to file? When the invention is 100% complete, or it is 60% complete or 80% complete. So when exactly you should file the patent application. So we'll discuss about it now. Recognition of patentability. How does a scientist know that an invention is worth patenting? The prime motivation to consider whether an invention is worth patenting or not comes normally from the working scientist. The working scientist, the inventor, can only say that yes, the my invention is very important, it is worth patenting. Uh, when it is a coming from any inventor, any scientist. But typically, what happens in India is not you know it is not so. What should I say? Uh, they don't really say that my research is not worth patenting. Everybody would say my research is worth patenting. And when it goes through the test of patentability, then it is found that the research was not patentable. Either the novelty was not there, or the patentability, the inventiveness was not there. But initially, everybody says yes, it is very important. So scientists should foremost apply their intuition to think about the practical applications of their work. That is, when it is commercially worthy, then they should not ignore it. They must file a patent application as per the system, which is in different institutions. It is different system. Like in IIT Delhi, the FITT has got a section which is responsible for filing patent application on behalf of IIT Delhi. Whereas in IIT Bombay, there is a different system. IIT Madras, there is a different system. IIT Kanpur, there is a different system because they don't have FITTs. So, like our research R&D department, Dean R&D, IRD section is there. There is a one setup is there, one addition section is there, which takes care of patent filing. A patent means disclosure of information to the general public. So, uh, uh, should you file a patent application right now with whatever results are there, or after some time? So this is something which is very important, and a careful examination of pros and cons and analysis is essential before filing a patent application. Uh, if an invention is patentable, it does not necessarily follow that it will result in a commercially viable technology or product. Sometimes both things are there. It may never be commercially viable technology, or it is possible that today you have taken a patent, something is there, it is not finding a utility, and therefore you don't get patent granted. But sometimes its use is not so explicit, it's so implicit, and subsequently you get the commercial worthiness of a patent. And for that matter, any research uh, you do, the research output may become useful maybe many years after the research. So a patent may be expensive and difficult to obtain, maintain, and enforce. All the three. Obtain, it may be expensive to obtain a patent. If you want to file a PCT application, or if you want to file patent in a developed country, USA, UK, etc., European countries, it is quite expensive. It costs you anywhere, 20 to 30 lakhs rupees, one patent filing. You have to have the fee there, you have to pay. There is no concession for the developing countries' patent applications, because it is the national treatment. You give the same national treatment to the people of all the member countries of WTO. So to obtain difficult, then you have to maintain every year, you have to pay the fee. In India, it may be 10,000 rupees, 8,000, then, no, 24,000 and like that in the next 4 years. But uh, for a small company and like that. But in uh, the developed countries, when you convert, rupee into pound, 104 rupees is 1 pound, 74 rupees is $1. So we are at disadvantage. So every year paying that much of money for renewal is also difficult, and enforcing the patent right. That is, you have got a patent in USA, you have got a patent in Russia. Now in Russia, such a big Russia, whether your patent is being infringed by anyone, how do you enforce that it is not being infringed by anyone? And even if it is being infringed by any person, with difficulty you come to know about it. You have to go to the court of law there, and in the court, you have to prove, you have to spend another 1 crore rupees to fight your case in the court, of which uncertainty is always there, whether your lawyer will be able to prove that there is infringement or not. And as typically happens that your lawyer, you are an Indian person in Russia, so the other person, infringer, is a Russian. He has got a lawyer who is also attorney, is also Russian. Your attorney is also Russian. So the two attorneys and the infringer, they are all hand in glove. They say, okay, I'll give you some money. Don't argue so strongly. Play it softly. So you may lose the case of, proving the infringement. So the enforcement also becomes a serious issue. Therefore, I put all the three: obtain, maintain, and enforce in bold. Decisions should primarily be based on the probability of obtaining commercially useful protection. Uh, so everywhere this is the system that it should be commercially useful, and if it is not commercially useful, uh, it does not really serve much purpose to spend so much of money. At the most, you can file in India, but um, don't spend too much of money on filing it in so many more countries. So this is very important when to take patent. Generally, as soon as you have all the necessary information required for drafting the patent application, uh, you file a patent application. The advantages are, as soon as you have. So ensure that you are the first to file a patent application, because the protection is given in other than USA, in every country. The patent is given on basis of first to file. So when you are, if you delay it and suppose somebody else files somewhere, so the two words are very important: as soon as you have and first to file. So if you delay it, then somebody else files the application with a similar invention, you will not get this thing, because the novelty will be of the person who filed it first. And therefore, it is useful if you are seeking financial support or wish to license your invention to commercialize it. Many times it happens that you say that you have already filed one patent, and in this research you need, 5 million rupees more, 50 lakhs more is required. So the people, the financial agencies, they will fund the research if they know that you already filed one patent already. So if you say you are applying for your professors are applying for funding for any research in DST, Department of Science and Technology, Ministry of Science and Technology, and they say that this is the research we have done, and we want to further do it, and these are advantages, and we have already filed one patent, or we got one patent granted or so. So they will get very quickly a good funding. And even if they file a patent, they will get a good, easy and fast financial support. Even the private sector companies will be interested in funding your, uh, you know, funding your research, because they know that you already filed a patent application. So if they are working in that field, they will be good sponsors. Now, what are the disadvantages? The disadvantages are, if applied early, generally it is not possible to make significant changes in the original claim invention. So if you prematurely do the patenting, then you may not be able to claim many more things which are in the process. But there is also a way for that. That is a provisional specification filing. In the next slide, I'll show you that. So you have to take the precaution. Any disclosure before filing the application for test marketing or to investors or other business partners should be done only after signing a confidentiality or non-disclosure agreement. Okay, so this is a precaution. If you are showing it to some investors, so you have to get a non-disclosure agreement that they will not disclose it to anyone, and so that your novelty is not lost. So this is very important precaution. Let me change the color of this into. The precaution is very important. Then in Indian Patent Act, there is a provision that invention does not lose its patentability during the grace period, which in Indian law is 12 months from the date of disclosure. So this was done in the last amendment about 10, no, 15 years back, that this, even when you go for this disclosure, up to 12 months, it does not, although it is only in India, but worldwide it will not be tenable. But in India, it is acceptable. The invention may thus be disclosed for the purposes of display in a trade exhibition, publishing in a company catalog, or technical journal. And patent can be filed within a period of 12 months from such disclosure in India, because the 12 month grace period is there. And this was put particularly keeping in view that in India, the academia, they want to publish papers first, and then, particularly when it is a matter of a PhD scholar and a professor, there is a conflict of interest. A PhD scholar would get a job after publications. So if publications are there, then the research scholar, after submission of the PhD, if the publications are there, he or she will get a job very quickly and in a good institution. But if you are delaying the publication because the patent is in the pipeline, then publication not there, so a research scholar may not get a job so easily in a good institution. So he or she wants earliest publication, whereas the professor wants that patent should be given, because publications are already there with the professor. There, you know, dozens of publications are there, hundreds of publications are there. So professor को इतना फर्क नहीं पड़ता है कि वो कहता है कि नहीं नहीं पेटेंट बहुत ज़रूरी है, पेटेंट हो जाने दो. So there is always some kind of conflict. So suppose it is published first, so it is public disclosure. So 12 months grace period is given in Indian law for the past 15 years or so. You can seek help of a patent agent. We already discussed, patent agent is a technical person. Normally the uh, uh, scientists and researchers are deeply involved in their scientific research, research and development, and may not be fully equipped to deal with the legal issues involved in the protection of their inventions. In such a situation, it is advisable that assistance is sought from a legal expert or patent agents in the preparation, filing, and processing of the patent application for the grant of patents. And scientists must learn to effectively communicate with the patent agent or patent attorney and in full confidence, because they are the people who are uh, well versed with filing patent applications. They have certain set of questions, whereas the professors and the research scholar are doing it for the first time or a few times. They are not that well versed, so there is a uh, apparently communication gap. They ask some question, so the research scholar or the professor, they are a bit hesitant. They think I should not give an answer to this. So it is same thing like police investigation. Uh, you know, you go for the police investigation, you are not too sure. Whatever you are giving the reply to the question to the police by to the investigating officer, that will be helpful to you or it will put you in trouble. So similarly, this kind of a dilemma is there in the minds of the researchers, but they should be very clear. It is not a they are not being prosecuted in a criminal case, so they should be very clear and honest in telling that these are the things. And now tell me what best you can get me, what best protection you can get me for my research, invention, and patent. We have discussed that patent agent is a person who has qualified the examination conducted by the patent office. Legal phase, these are the steps to grant of patents. Uh, Filing provisional or complete specifications. Now, publication including a title and abstract, full text available on request within 18 months or early request by an applicant. So, uh, then this you first take the left side, then we come to the right side. Filing a provisional or complete specification. Provisional application or complete application. So publication including title and abstract and full text available on request. Then you request for examination. When you request for examination, then it is examined, not otherwise. And after the examination, it is a formal examination, a substantive examination. And once it is ready for grant, it is a pre-grant opposition. A window is given to the people who want to oppose your patent. That is known as pre-grant opposition. Then, if the opposition is not valid or opposition is if the grant of patent is there, so then also there is possibility of post-grant opposition. But post-grant opposition is very less because it has to be a really, a very good case for post-grant opposition. Now, the application is a single inventive concept. You can't put 10 inventive concepts in one patent. For 10, you should file 10 patent applications. Now, for publication, it is the 18-month period. In 18-month or early, there is also a provision in the our National Patent Act to request for uh, uh, or early request for by the applicant. So you can ask for that by paying higher fee than by the applicant or interested person. 48 months deferred examination system is also there. You can delay your patent this thing uh, for certain reasons. If you think that uh, you want to, another patent is in the pipeline and you don't want to disclose that particular thing which is already there, so you ask for deferred examination, that is delay the examination, you can do it. Then they are down for opposition, one can oppose this thing within 1 year from the publication of the grant, pre-grant application. So that is a 1 year period is given. In the filing the patent application request is to be made in form number 1. The basic information to be provided about, for example, the title of the invention, applicants, inventors, and other formal requirements. They are to be filled in. The application may be filed in the patent office at Kolkata or its branches Delhi, Mumbai, or Chennai, depending upon the respective territorial jurisdiction. Uh, the jurisdiction where the application is to be filed is determined on the basis of place of residence of the inventor or the applicant. If it is a company, though it is not the residence. In case of a company, it is the head office of the company or the branch office of the company. Then domicile or business of the applicant, residence. So residence or business location of the applicant. Then which should be mentioned by the applicant in the case of joint applicants. So it will be the first applicant's residence or the thing, not the second applicant. One applicant may be in Delhi, other may be in Chennai, second one. So it will be Delhi patent office will be the place where you have to file the application. A place from where the invention actually originated or the address for service in India given by a foreign applicant. These are the possibilities. Who can file an application? Patent application can be made by the true and first inventor or his assignee if you have assigned it to someone, or legal representative of a deceased inventor or assignee, either alone or jointly. A firm or an R&D organization as assignee of the true inventor. Uh, you can uh, you can be you can be an inventor, but you do not know how to file a patent application, etc., and how to go about it. So there is an organization called NRDC, National Research and Development Corporation, located in Jamrudpur in Khelgaon Marg, August Kranti Marg. You are aware of Jamrudpur, which is just a few kilometers away from IIT Delhi. So they that firm, you assign your patent right to them under with some agreement that they will try to commercialize your patent, and the total after commercialization, the revenue they get will be shared between them and you. So um, that is such organization are there. You can assign your patent. Now this is very important: provisional or complete specification, which everybody must know. See, when you file a patent application, you can request for application to accompanied by provisional specification or complete specification of your patent or the invention. So provisional specification is something which is provisional and not complete. So in the provisional application, you may not even give the complete specification, that is fine, and submit details of the specification in form number 2 later on. So the provisional specification may be filed when an applicant finds that his invention has reached a presentable form. So he says, I can file a provisional application. On filing the patent office immediately accords a filing date for the application. And the date which is given, this date, the advantage is the date becomes the priority date. When you're filing the provisional application without all the specifications, complete specification, so that particular date becomes the date of priority. And within 1 year, you can file the complete specification. So such application essentially contains the title and description of the invention, object of the invention, and a general statement of the actual invention. The claims need not be included in the provisional specification. So the most important difference is the claim, because you're doing further research, and accordingly you can decide what should be the claims in that thing. So once you put the claims, your provisional application becomes the complete application. So your provisional specification becomes complete specification. So claims is the only thing which is not there in the provisional specification or the provisional application. And it enables the applicant to disclose the invention at an early date to claim priority over any other applicant who may be working on the same invention in some other part of the world. The complete specification needs to be filed within 12 months, I told you just now, from the date of filing of the application, during which the applicant can fully develop his or her invention. So within 12 months, you can file your claims, but you get the same date of priority. So the complete specification would include title, field of invention, state of the art in the field, object of the invention, statement of the invention, detailed description of the invention, scope of the invention, and claims. When you say complete specification, the claims are there. Any question?
सब claims exactly क्या होते हैं?
क्लेम होता है जिसके ऊपर आपको प्रोटेक्शन मिलता है. आपका जो प्रोटेक्शन है ना इन्वेंशन का, वो आपको क्लेम के ऊपर ही मिलता है कि व्हाट यू क्लेम इन योर इन्वेंशन, व्हाट इज योर इन्वेंशन. आप करते हैं ना, ये मैं क्लेम करता हूँ कि मेरा ये इन्वेंशन है. तो जो इन्वेंशन है उसके ऊपर आपको जो आपने क्लेम में लिखा है, प्रोटेक्शन इज लिमिटेड टू दैट ओनली.
सर वन क्वेश्चन.
हाँ,
ये सर, ये प्रोविजनल मींस ये मतलब एग्जैक्टली क्या हुआ कि मतलब बिफोर यू गिव ए कंप्लीट स्पेसिफिकेशन इट्स जस्ट ए सम प्रीलिम.
प्रोविजनल में आपने क्लेम नहीं दिए, बाकी सब दे दिया. और जो
अच्छा.
क्लेम आपके फाइनलाइज नहीं हो पाए थे तब तक. देखिए, आपको एक रिएक्शन हो रहा है लैब में, ठीक है, बड़ा लंबा एक्सपेरिमेंट चल रहा है, 3 महीने से चल रहा है, 4 महीने से, और वो एक्सपेरिमेंट जो है कंक्लूड होने वाला है. तो आपने देखा कि इसके इन कंडीशंस के ऊपर ये एक्सपेरिमेंट का ये रिजल्ट आता है, विच विल गिविंग अस द न्यू दिस प्रोडक्ट और इन्वेंशन के बेसिस पे ये हमने नया बनाया. तो जो बनाया है हमने, वो उसका टेम्परेचर था, जो मैंने पहले भी एक बार सिंपल स्टैंडर्ड में कहता हूँ कि चलो वो 70 डिग्री सेल्सियस पे रिएक्शन इज टेकिंग प्लेस. तो अब आप उसको कर रहे हैं कि वो 70 पे है, उसके क्या ऑल्टरनेटिव्स हो सकते हैं. तो वो आप क्लेम में करेंगे कि अगर 70 पे करेंगे तो आपको ये होगा, और हमारा ये उसके ऊपर क्लेम है. तो पेटेंट अटॉर्नी कहेगा कि अगर आप 70 की जगह 69 पे करेंगे तो हो जाएगा क्या. तो आप कहते हैं हो भी सकता है, नहीं भी हो सकता है. तो क्या अगर 72 पे करेंगे, 70 डिग्री सेल्सियस से होकर रिएक्शन तो हो सकता है. तो आप कहते हैं कि पॉसिबिलिटी तो है, नहीं होगा, पर हो भी सकता है अगर कुछ हाई प्रेशर कंडीशन हो और कुछ हो तो इस तरह से आपने जो कंप्लीट आपका रिसर्च कंप्लीट नहीं हुआ है अभी तक, तो यू आर नॉट इन ए पोजीशन टू एग्जैक्टली टेल द अटॉर्नी कि मेरा क्लेम जो है वो क्या है. तो क्लेम को फाइन ट्यून करने में आपको 2-4-6 महीने और लगेंगे, आपका जब तक और रिसर्च हो रही है. तो आपको है कि आपके रिसर्च के आउटपुट की जो प्रायोरिटी डेट, तो जो आपने पहले कर दिया प्रोविजनल एप्लीकेशन में, प्रोविजनल स्पेसिफिकेशन में, उसमें यू हैव पुट एवरीथिंग अदर देन द क्लेम. क्लेम है जिसके ऊपर आपको प्रोटेक्शन मिलेगा. और आपने कहा कि ये रिएक्शन टेक प्लेस एट 70 डिग्री सेल्सियस. सम अदर कंपनी यूजेज द सेम पेटेंट्स एवरीथिंग, बट दे डू इट एट 69 डिग्री सेल्सियस. तो आपका तो क्लेम है ही नहीं 69 डिग्री सेल्सियस की रिएक्शन के ऊपर. तो आपका जो पेटेंट है उसका कितने क्लोजली दे आर यूजिंग योर इन्वेंशन, एंड यू कांट डू एनीथिंग अबाउट इट, because you are not claimed that it will also happen at 69 डिग्री सेल्सियस. कोई रिएक्शन है तो अटॉर्नी कहेगा कि भैया देखो ऐसा करते हैं हम इसको कर देते हैं कि 70 माइनस प्लस 10, दैट मीन्स 60 डिग्री सेल्सियस से 80 डिग्री हो जाएगा। तो आप कहते हैं हाँ हाँ, इससे बियॉन्ड नहीं जाएगा, ये तो 100% इसी में ही रहेगा। तो क्लेम में वो कर देता है कि 70 माइनस प्लस 10%, सो आपका 60% से 80% तक है। तो आपका क्लेम जो है उसका ही, उसी को पर प्रोटेक्शन मिलेगा। Am I clear about it?
Yes sir. And sir, कितनी देर तक ये रहता है प्रोविजनल?
1 साल तक।
Okay, within 1 year you have to put the claim.
हाँ, क्लेम आपको 1 साल के अंदर देने होंगे। उसका एक फॉर्म नंबर है, होते ना 30 फॉर्म से, उनमें से एक है जिसमें आपको क्लेम डाल सकते हैं बाद में टू कंप्लीट देयर स्पेसिफिकेशन। ठीक है, मैंने अभी पहले भी बताया था, यहाँ पे देखो ना, द कंप्लीट स्पेसिफिकेशन नीड्स टू बी फाइल्ड विद इन 12 मंथ्स। तो ये एब्स्ट्रैक्ट्स एंड ड्राइंग सब चीज़ें कंप्लीट स्पेसिफिकेशन में आ जाती हैं। देन इन केस ऑफ बायोलॉजिकल मटेरियल मेंशन्ड इन द स्पेसिफिकेशन, जो बायोटेक्नोलॉजी के होते हैं, तो they may have to be deposited with an international depository authority IDA under the Budapest Treaty. And in India at present there is one such IDA recognized by WIPO known as Microbial Type Culture Collection and Gene Bank, MMTC, operated by the Institute of Microbial Technology, Chandigarh. We deposit the microorganisms if it is the research of that type. Then there is a concept of single inventive step or basic principles. The single inventive concept is, it means that it should be possible to say in respect of such a group of inventions that all the inventions are technically linked together as to form a general, single and integrative inventive concept. That means, in a sense, there should be a technical relationship among the inventions that involves at least one common or corresponding technical feature over the prior art. So then you can say it is a single inventive concept. I'll give you some examples also. The single inventive concept, problem to solution, inventive when makes contribution over prior art, then it is the inventive. Then general when it applies to more than one invention, single when it applies to all the inventions in the application. And example, a pair of eyeglasses and a door handle, a bicycle and a camera, these are independent inventions. Okay, they are all, it is eyeglasses single inventive concept and door handle is single inventive concept. So these are two different independent inventive steps. A bicycle and a camera, again there are two independent inventions, independent two independent single inventive concepts. Single inventive concept, sewing needle with eye at the bottom and sharpened from the bottom, the eye at the bottom and sharpened from the bottom. So in the sewing machine we have this kind of needle. इन द जो हम बटन लगाते हैं घर पर, उसके लिए जो 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 ये है ना, दिस होल आई ऑफ द, ये आई, ये यहाँ पर होता है ऊपर को, नॉट एट दिस पॉइंटेड प्लेस। डिफरेंस है ना दोनों में। तो देन कोटिंग्स ऑन द वायर एंड द नीडल्स, स्पेशल मेटल अलॉय ऑफ द नीडल, फॉर्मेशन ऑफ द अपर्चर टू फैसिलिटेट इजी मूवमेंट ऑफ द थ्रेड, देन इंटरलॉकिंग सिस्टम फॉर द थ्रेड। तो ये सारे के सारे जो हैं, they are all related to each other and therefore they are the single inventive concept because they are all related to each other. जो सब चीज़ें related हैं एक दूसरे से, तो you can put in your claim as claim number 1 independent claim, claim number 2 may be based on claim number 1, or claim number 2 may be also an independent claim. Claim number 3 can be based on claim number 1. Claim number 4 can be based on, may depend on claim number 2. And claim number 5 is based on or depends on the claim number 1 and claim number 2 both. So all such possibilities are there. Undertaking regarding foreign applications, an applicant has to keep the patent office updated with the prosecution of his patent application for the same or substantially the same invention in any other foreign country. If you apply your patent application, you are applying to a foreign country, you have to keep your patent office in your country updated about it. The declaration has to be made in a prescribed form. उसके form है, out of the 30 forms we talked about. You have to say that this I am applying for this patent in that country also. So you have to fill the form and pay some small fee. The detailed particulars of such application have to be provided by the applicant to the patent office in the particular form. And if there is no foreign filing, then applicant may give a nil statement, that is, you're not filing a foreign filing in that form. I'm not very, I have to go through this in more detail. Why you have to fill the form by saying nil statement, I'll find out. The publication and examination of application. The Deferred Examination System DES was set up after the introduction of the provision of Patent Amendment Act 2002 after 20th May 2003. Under this system, all the applications are kept secret and are not open to public for a period of 18 months from the date of filing the patent office. After expiry of the said period of 18 months, the applications are published in the official journal, which is published weekly on every Friday. That you already know now. The applicant can also make a request for an early publication in the prescribed manner by payment of a particular fee. The publication of the application in the official journal includes the particulars of the date of application, application number, name and address of the applicant, and the abstract. It is not full patent application not published, it is only the abstract. On publication of the application, the full text is open for public inspection on payment of a prescribed fee. So once after 18 months, your patent abstract is published. So those who feel interested in your patent abstract, based on the patent abstract, they feel interested in getting the full text of your patent application, they can pay some fee and they will be provided the full text of your patent application. Now, examination by the patent office. First examination report is for formal defects, for technical defects, for legal defects, for patentability criterion, or for wordings. These are the 5 things for which in the first examination report, and the academic institutions, they get some queries for this on basis of the first examination report of the patent application. And large number of them, for whatever reasons, they are not able to respond to the patent office, and they say you give all these things within 3 months, and when there is no reply from any academic institution, then they will abandon the patent application. They will not take it further. And typically what happens that when the first examination report comes after 18 months and all that, or before 18 months, the research scholar has got some job. That research scholar may be busy in teaching job, where he has to prepare his classes, the course he has been asked to teach. So his daily workload is so high that he is drifting away from the PhD research and the patent they had filed. And professor has got many more current students with whom he is busy. He has got some administrative responsibilities in that institution, maybe dean or some other thing. So he is busy. So both are busy, and the 3 months time period is passes away, and they are not able to respond to the patent office query on the first examination report. Then it can be on the claims not clearly worded. The claim should be very clear. The claims are not definitive, or description is ambiguous, or as worded there is no invention. It happens sometimes the way you say that this is an invention, there is no invention. Or is there any inconsistency, or the claims lack support in the description. The drawings are there, description is there, or unclear description with reference to the drawings. So all these cases there can be a question from the patent office. Then opposition proceedings, pre-grant opposition by the representation, post-grant opposition by representation, and statutory ground of opposition. All the three things are possible. Statutory ground for opposition can be, it can be anything. Maybe that by mistake the patent was granted by the patent examiner. How do you rectify the mistake? There is no opposition. Okay. But internally they find and they say we are on statutory grounds we are rejecting the a particular patent. Then pre-grant opposition is the publication of the patent application allows any interested person to look into the full text of the patent application and take a view whether the grant of patent is to be opposed on the basis of specific grounds. The applicant may have any broad interest in making such opposition on strategic, economic, competitive, legal, or any other such aspects. So on any of these considerations, any person, any company can oppose the patent by making the application of opposition in a form, particular form is there for that. Then the pre-grant opposition can be made after the publication of the application but before the grant of the patent. If there is no opposition, the application is taken up further for the patent, grant of patent, and there is no ground other than the statutory grounds can be taken for opposition a grant. The pre-grant opposition is disposed of by giving an opportunity of being heard to both the parties. The person who is in the patent office, normally the assistant controller of patents or the deputy controller of patent. So at that level, they give hearing to both the parties, who is opposing and who is not opposing. Not opposing, the applicant and the person who is opposing, or the company who is opposing. The grant of patent, the patent is granted to the applicant when the application is found in order for grant and there is no pre-grant opposition, or in case the pre-grant opposition, the same has been disposed of in favor of the applicant. Patent certificate is issued to the patentee by the patent office. After the grant of patent, the same is published in the official journal of the patent office. Every Friday it is there. Now the post-grant opposition by representation is after the grant of patent, any interested person can file an opposition known as post-grant opposition before the expiry of 1 year from the date of publication of the grant of patent. The representation needs to include a statement and requisite supporting evidence and has to be in the prescribed forms and deposition of the prescribed fee. And also stating that why it was not opposed as the pre-grant stage, why you are opposing it in the post-grant. So you have to justify that also. The controller will consider the presentation and will give notice to the applicant if he feels that the application requires amendment. The disposal of post grant opposition is made by the opposition board, which, after considering all the documents, gives its recommendation to the controller for final decision. Yes. Any question?
So,
Yeah.
means a patent owner is not completely out of risk zone till 1 year. Anyone can oppose his patent.
Yeah, post grant opposition is possible.
So, but once that 1 year period is over, he can be a little relaxed that now his patent, he's in that state.
Absolutely. तो है ना, 4 फेरे के बाद क्या होता है और 7 फेरे के बाद क्या होता है, वो वाली बात है ये, ठीक है। जस्ट टू गिव ए सोशल बैकग्राउंड एग्जांपल, तो हिंदू मैरिज सिस्टम में 7 फेरे के बाद में शादी पक्की हो जाती है, 4 फेरे के बाद शादी पक्की नहीं होती। वो आता है ना मूवीज में दिखाते हैं, वो 7वां फेरा वो जल्दी जल्दी लगा लेते हैं, वो जो होता है ना हीरो हीरोइन कर मिलके फटाफट 7 फेरे कर लो, शादी पक्की मानी जाएगी। फिर तो 1 साल के बाद में वो पक्का हो गया उसका। The application will not be published if the invention relates to national security. No person resident in India is entitled to make any application outside India for grant of patent for an invention unless an application for the same has been made in India not less than 6 weeks before the application made outside India. It is believed that you make an application in India and give this thing that you want to file this patent application abroad also, very quickly. So if you don't receive a reply from the patent office within 6 weeks, you can go ahead and file your patent application abroad. Okay. Because what used to happen earlier, you had to, as typically what happens in the government offices, they are sitting on your paper, they are not disposing of this thing. After 6 weeks हो गया, 1 month हो गया, 2 month हो गया, 3, 5, 6, 8 months हो गया, 11 month हो गया, अब आपको 12 month के अंदर फाइल करना है. Now you are in very difficult situation how to file within 1 month in 10 countries. तो वो कहेंगे कि हमें थोड़ा सा द ड्राइविंग सिस्टम ऑल्सो एवरीवेयर इन द कंट्री, कि हम आपको जल्दी से आपका फाइल को देख लेते हैं. तो सिस्टम बन गया कि आपका 6 वीक तक अगर उन्होंने उसको रोका नहीं, अपोज नहीं किया, तो 6 वीक के बाद में यू कैन फाइल योर पेटेंट एप्लीकेशन अब्रॉड. और दिस सेक्शन विल नॉट अप्लाई फॉर एप्लीकेंट्स रिजाइडिंग आउटसाइड इंडिया. ऑन NRI it doesn't apply. NRI, आपका कोई NRI अमेरिका में, वो अमेरिका में पेटेंट फाइल कर सकता है, कोई प्रॉब्लम नहीं है इसमें. Foreign filing by Indians. If any application is to be filed abroad without filing in India, it should be made only after taking a written permission from the controller. इसका क्या पॉसिबिलिटी है, कहाँ हो सकता है? Like without filing in India, when this is possible, कि आप इंडिया में फाइल नहीं कर रहे हैं, बिकॉज इट इज़ नॉट पेटेंटेबल इन इंडिया. आपका न्यूक्लियर टेक्नोलॉजी के ऊपर आपने कुछ इन्वेंशन किया, अब इंडिया में तो पेटेंट मिलेगा नहीं, तो आप इंडिया में पेटेंट फाइल नहीं करेंगे उसका. तो व्हाट यू डू, यू वांट टू फाइल इट इन USA. आप USA में पेटेंट फाइल कर रहे हैं अपने न्यूक्लियर इन्वेंशन का, तो पेटेंट फाइल करने से आपको उसकी एक रिटर्न परमिशन लेनी होगी कंट्रोलर जनरल ऑफ पेटेंट डिज़ाइन, मतलब पेटेंट ऑफिस से. एंड पेटेंट ऑफिस इस तरह की जो इन्वेंशन है उसकी जो फाइल है, वो आप कह रहे हैं कि ये मुझे फाइल करना है वहाँ पर, ये मेरी पेटेंट एप्लीकेशन है. दैट पेटेंट एप्लीकेशन जो इंडिया का जो पेटेंट ऑफिस है, दे विल फॉरवर्ड इट टू द जो न्यूक्लियर पेटेंट्स को जो देखता है इंडिया में, दैट इज़ द बार्क, भाभा एटॉमिक रिसर्च एजेंसी जो है, भाभा एटॉमिक रिसर्च कमीशन. तो बार्क में जो उनका पेटेंट ऑफिस है, वो एग्जामिन करते हैं ऑन बिहाफ ऑफ द पेटेंट ऑफिस गवर्नमेंट ऑफ इंडिया, on any invention, whether it is threat to India's security if it is filed abroad or not, and if it is not so, they will allow, and then that particular recommendation is endorsed by the patent office, because in patent office you don't have atomic energy experts. So a gist of invention should be filed along with the Form 25 for filing abroad. There are certain precautions that need to be kept in view by the applicants. These include not to publish their inventions in newspapers or scientific and technical journals before applying for patent, except under certain exception circumstances. India में जैसे law में है, not to use the invention in public or commercially in public or even in secrecy prior to the date of filing of the patent application. The secret working of the invention by way of reasonable trial or experiment, or the disclosure of the invention or other persons confidentially may not result into loss of novelty. इसमें जो है may not result into ये सबसे important है, any such thing should not result in the loss of novelty. Now, general precautions: not to wait until their inventions are fully developed for commercial working before applying for patents. A provisional application कर सकते हैं. Apply for a patent as soon as inventor's idea of the nature of invention has taken a definite shape. Not to neglect the issues of sharing of rights with reference to those of their employers, co-workers, contractors, and assistants, if any, as per the acceptability to all the parties or as per the system with whom they are brought into contact in the course of the development of their invention. Now, say as per the system, अगर एक PhD स्कॉलर है, एक प्रोफेसर के अंडर में काम कर रहा है और लैब में एक लैब असिस्टेंट को असिस्ट करता है, तो इसका मतलब ये नहीं होगा कि आप लैब असिस्टेंट का भी इन्वेंटर में नाम दें हर बार. आपने कुछ इन्वेंशन किया, उसको पेटेंट हुआ है फाइल, तो उसमें बिकॉज दैट पर्सन इज सपोज टू हेल्प यू, ही इज बीइंग पेड सैलरी फॉर इट. तो इन्वेंशन में पर से उसने कुछ रोल प्ले नहीं किया है. जो इन्वेंशन का जो कंसेप्ट है, जिसमें आपका जो इन्वेंशन हो रहा है, उसमें जो प्रोफेसर रिसर्च स्कॉलर का ही सारा दिमाग लग रहा है ना. Then it is important that you should maintain proper records of research, otherwise somebody else may claim the priority by showing their record. Or when you say that it is your patent, but somebody files a suit against you, no, it is not your patent, so you can show the record in a court of law. It is for your own protection, the company's protection when R&D department of a company. So in all the labs, whether it is academics or in R&D institutions or R&D department of a MSc or any company, they should maintain proper records of the research, what is done what day. So document is required for filing the application in applicant form, duplicate form 1, drawing in duplicate if necessary, abstract of invention in duplicate, information and undertaking, listing of the number, filing date, etc. These things are there, all in duplicate if it is being given in the physical form, and if it is e-file, then no problem. Then document required for filing: priority document if date of priority is claimed in convention applications. Convention means Paris Convention. When directed by the controller, suppose you are somebody is filing a patent application in India's patent office, and that person is claiming the priority. The person is a foreigner, is filing it as such, or he is claiming a priority of the patent, priority date. So that should be disclosed in particular form. And then declaration of the inventorship, where provisional specification is followed by completed specification, or in case of invention, convention or PCT national phase application. PCT का जब एक बार इंटरनेशनल फेज के बाद में जब नेशनल फेज में आएगा, that also should be informed. Then power of attorney, if filed through a patent agent, you give the power of attorney for filing purpose, not for ownership, but only for filing purpose. You give the power of attorney. Then fee can be paid in cash or by check or DD. Then request for permission to file abroad. Then if any application to be filed abroad without filing in India, it should be made only after taking written permission from the controller in form number 25. 6 weeks में परमिशन नहीं आती है आपकी, तो यू कैन फाइल दिस थिंग सेइंग दैट कि 6 हफ्ते तक आपने जवाब नहीं दिया तो हमने फाइल कर दिया. This is as per the law. These are the managerial issues. Make sure that there is clarity on the issues of relating to rights over the invention, maintaining confidentiality of R&D information, basis of naming the inventors. बाद में dispute नहीं होना चाहिए कि इसका नाम पहले है उसका बाद में है, तो पहले से ही there should be clarity on these issues. Then employer versus employee inventions and commercialization of the patents, how they should be. These are all the managerial issues. Then utilization of the patent information in R&D and business, patent analysis, indicators and mapping, keeping records of research, evaluation of merits of invention from the economic point of view, evaluation of patents, negotiating licensing of patents, including transfer, acquisition, and adaptation of technology from domestic sources as well as from abroad. So these are the things which are important. I'll just give you an example what happens once. Just remind me. Then protection of confidential information by the employees while making essential disclosures while in service, after termination of the services, after considering compensation to the employees, while considering compensation to the employees, and releases from confidentiality. All these things are important from managerial point of view. And maintaining record for research, I have told you that all the whatever research is done every day, you should keep a record of it. And a patent on its own is no guarantee of commercial success. It needs to be exploited effectively in the market. To take a patented invention to the market, a company has a range of options, which I discussed earlier. Commercializing a patented invention directly by company itself, selling the patent to someone else outrightly, or licensing the patent to others on exclusive or non-exclusive basis, then establishing a joint venture or other strategic alliance with others having complementary assets. These are some of the things, you know, I have already shown you this thing. ये जो था ना इसमें मैं बता देता हूँ. हाँ, एक बार क्या हुआ, एक कंपनी ने इंडिया IIT दिल्ली को स्पॉन्सर किया रिसर्च, और उन्होंने कहा कि दिस इज द एग्रीमेंट IIT हैज टू साइन. तो जो एग्रीमेंट टू बी साइन, so the dean at that time, it is 20 years back, the dean asked me to just go through the licensing agreement which they are proposing. Maybe that nowadays, whoever the dean research and development has a fairly good idea about the IPRs and all that, but in those days the dean R&D were not having adequate idea about the IPRs. So he went through it. He felt that it would be good if he asked my opinion on it. This document said, the condition said that after we are sponsoring research, the output will be totally the property of the company who is sponsoring the research in 10 lakhs rupees. And after this research, whatever research is done in IIT Delhi on this topic will be the property of that company. But that's ridiculous. How can you have in next 100 years, whatever research is done in IIT on this topic will be the property of that company? So gave my opinion on this thing, and then we, they discarded the whole thing. You can have any sponsoring research, any company sponsoring research in India can only say that कि इस रिसर्च के ऊपर हमारा पेटेंट होगा या जॉइंट पेटेंट होगा, पर ये थोड़ी उस रिसर्च के रिलेटेड जो भी रिसर्च होगी IIT में लाइफ लॉन्ग उसके ऊपर उस कंपनी का राइट हो गया. So it is already 3:30. So any question? As next time I would like to talk to you on one issue, that is the licensing, and negotiation. So one day I will talk to you on licensing, one day I'll talk to you on negotiation. Okay. When I talk to you on negotiation, I'll also talk to you about the portfolio management, patent portfolio analysis, and patent pools. Okay. So maybe that this week I'll cover these two. Any question?
So one thing. So when we say like somebody filed for his patent on a particular day, and if the patent is granted finally, so the day he filed is supposed to be his registration date?
Priority date. It is known as priority date. All his or her rights or the company's right start from the date of priority date.
Right, sir. So what is the registration date then? The day when it is granted?
There is no registration. It is a date of grant. The date of grant is when you know that it has been granted to you finally. Okay, after your application, the grant is the date of grant, but your rights start from the date of priority, the date on which you filed the application. Is that clear?
Yes, sir. But then you had given us for our term paper, there are 2-3 heads. One of the head is registration. So what are we supposed to write here?
It was a registration is for other than patents. So whether the GI is registered.
I'm talking of GIs in context of GIs.
So GI तो registration, GI का registration होगा, उसमें grant नहीं होगा ना. GI is registered.
So for registration, which date will put, which number will, or what will be the figure there? The date when it is filed?
See, invention में priority date is very important. क्योंकि parallel invention हो रही जगह-जगह, research and development हो रहा है. But जो GI है, वो दार्जिलिंग की हजारों सालों से है, अच्छी चाय है, तो उसका तो जिस भी दिन आप करेंगे तो उसका तो डेट ऑफ रजिस्ट्रेशन इज इम्पोर्टेंट. उसमें है कि आफ्टर द डेट ऑफ रजिस्ट्रेशन no WTO member country can use that particular name of the GI product.
तो और GI के कॉन्टेक्स्ट में डेट ऑफ रजिस्ट्रेशन और फाइलिंग डेट सेम होती है या अलग?
नहीं. आपका फाइलिंग डेट इज नॉट सो इम्पोर्टेंट, इज द रजिस्ट्रेशन डेट इज इम्पोर्टेंट.
सर एक क्वेश्चन है, जैसे अभी आप बात
इज इट क्लियर? ये रजिस्ट्रेशन डेट का हो गया. GI में जो डेट ऑफ रजिस्ट्रेशन इज द मोस्ट इम्पोर्टेंट थिंग, विच इज एनालॉगस टू पेटेंट के केस में जो डेट ऑफ ग्रांट है ना. बट इसका जो प्रायोरिटी डेट है, आपको जो तो आपके राइट्स होते हैं वो आपका फाइलिंग डेट से होते हैं पेटेंट में. बट जो GI का रजिस्ट्रेशन है उसमें आपको किसी भी डेट को आप फाइल कर दो, उससे कुछ फर्क नहीं पड़ता. वो आपका जिस डेट को रजिस्टर हो गया वही डेट है जो कि इम्पोर्टेंट है वर्ल्ड के हर कंट्री के लिए. जिस दिन हमारा GI रजिस्ट्रेशन हो गया था दार्जिलिंग टी का, जिस डेट को, उस डेट के बाद में कोई भी चाय की कंपनी किसी भी कंट्री की जहाँ चाय ग्रो करते हैं या चाय को ट्रेडिंग करते हैं, दे कुड नॉट कॉल एनी अदर टी एज दार्जिलिंग टी अनलेस इट वाज फ्रॉम दार्जिलिंग ओरिजिनली. ओके, Is that clear? Then I come to the next question.
yes, that is clear. But one of the site and it was WIPO का ही कोई छोटा साइट था, उसी का कोई मतलब सब साइट था. वहाँ पे WIPO वर्ड that साइट का ही कोई सब साइट था. उसमें ये लिखा हुआ था, if registered, the date of filing of the application shall be deemed to be the date of registration. So ये GI के context में मैं बोल रही हूँ.
I will check it and then confirm. Okay. मेरे को देखना पड़ेगा क्योंकि आपने एक एप्लीकेशन कर दिया. एप्लीकेशन करने के बाद सपोज रजिस्टर्ड नहीं हुआ तो सपोज.
हाँ सर, इसलिए डाउट है कि
इसीलिए तो मैं कह रहा हूँ ना कि मतलब प्रीमा फेसी शुड बी फ्रॉम द डेट ऑफ रजिस्ट्रेशन. वो
Yes.
कहाँ पे पढ़ा एक्चुअली क्या है. देखो बहुत सारी चीज़ें हैं जो कि आजकल इंटरनेट पे देखते हैं हम. जिसकी जो मर्जी आती डाल देता है. विकिपीडिया में जो मर्जी आती डाल देते हैं. सब रिवीजन होता रहता है हर चीज़ का. तो किसी ने गलत चीज़ डाल दी. बहुत सारी चीज़ें होती है. एक बार एज इम्पोर्टेंट एज ए थिंग ऑफ KBC एक क्वेश्चन था करीब 1.5-2 साल पहले. एक क्वेश्चन पूछा गया. हमने कहा कि इसका ये करेक्ट आंसर है. पर वो उसके KBC के जो भी उन्होंने देखा था उसमें उन्होंने गलत देखा था और गलत को उन्होंने सही करके उसको वैसे ही डिसीजन लिया उसका. बट दैट वाज द रॉन्ग क्वेश्चन. मतलब द आंसर जो KBC ने जिसको राइट आंसर माना था दैट वाज रॉन्ग आंसर. दैट वाज नॉट करेक्ट. और फिर उसके बाद में मैंने देखा कि जहाँ उसको देखा कि उसमें वाई इट इज़ नॉट करेक्ट. तो मुझे एक वो दिखा कहीं पर इंटरनेट पे कि वो गलत आंसर को उसने सही बोला हुआ था. तो अब वो जो जो इनकी जो रिसर्च टीम है KBC की दे टेक दीज थिंग्स फ्रॉम समवेयर. वो आदमी इतना पढ़ा लिखा मतलब उसको हर चीज़ का नॉलेज है नहीं ना. तो जिस जहाँ से उसने लिया वहाँ पे उसने गलत दे रखा था. उसने गलत ले लिया. अब दिस इज नॉट माई ड्यूटी. मैं KBC को करेक्ट करूँ. उनकी रिसर्च टीम को करेक्ट करता हूँ लाइफ में. बट आई न्यू कि दैट वाज नॉट करेक्ट. इट वाज समथिंग मेरे को याद नहीं आ रहा है इसमें क्या था. इट वाज समथिंग विद द कुछ इंडिया की इंडस्ट्रियल पॉलिसी और कुछ इस तरह का कुछ था वो. याद नहीं आ रहा. कुछ इस तरह का मतलब इंडिया के इकोनॉमिक पॉलिटिक्स से रिलेटेड था. जॉइंटली विद इकोनॉमिक पॉलिटिक्स. तो कुछ इवेंट था. तो आई न्यू वेरी क्लियरली. पर वो उन्होंने गलत को सही कर दिया. ठीक है. तो ये भी हाँ मुझे यही लगता है कि इसमें जो है ना मतलब वो आपने अप्लाई किया प्रोड्यूसर्स ने और सारी दुनिया को आप रोक देंगे कि आप रुक जाओ. नहीं कर सकते हो आप. और फिर आपको खुद को ही अलॉट नहीं हुआ. वो रजिस्टर ही नहीं हुआ. डोंट यू थिंक इट इज एब्सर्ड. आपका जितने रजिस्ट्रेशन हो जाएगा और इसका जो अपोजिशन होता है अपोजिशन के बाद में आप उसको कहते हैं कि आज से रजिस्टर हो गया. उसके बाद ही तो बंद होगा ना. तो दैट इज हाँ. अच्छा नाउ सेकंड कौन पूछ रहा था मुझे क्वेश्चन.
हाँ सर, आपने कहा था कि फर्स्ट टू फाइल इसमें आता है ठीक. बट यूएस के अंदर आपने बताया था कि यूएस में अगर आप रिकॉर्ड मेंटेन करते हैं तो अगर आपने फाइल लीक भी किया है, इफ यू कैन प्रूव दैट इट इज एन ओल्ड, यू हैव डन द रिसर्च बिफोर एंड यू कैन प्रूव दैट दिस पेटेंट कैन बिलोंग टू यू, इज इट स्टिल वैलिड और अभी फर्स्ट टू फाइल हो गया वहाँ पे यूएस?
वहाँ पर हो गया है जहाँ तक मेरा ख्याल है. फर्स्ट टू फाइल हो गया वहाँ पर भी. Because they fell in line with the rest of the world. क्योंकि इसमें कंफ्यूजन होता था ना. तो मेरे ख्याल से उनको 10 साल हो गए इसको फर्स्ट टू फाइल किए हुए. पर पहले नहीं होता था उनके यहाँ. आई थिंक इट्स अबाउट 10 years बैक दे चेंज. 2012 के करीब में चेंज किया उन्होंने इफ आई रिमेंबर करेक्टली. पर बिफोर दैट वाज फर्स्ट टू इन्वेंट.
थैंक यू सर.
चलो एनी अदर क्वेश्चन. ये अगर मालूम पड़ जाए ना तो इसको जरा सा मुझे उसको मैसेज डाल देना कि इस ईयर से यूएसए में फर्स्ट टू फाइल हो गया है. आई थिंक इट इज 2012 इफ आई रिमेंबर करेक्टली.
ओके सर.
चलो ओके देन.
Thank you, sir.
Thank you. All the best.